Hello and welcome to this HRLA event on the theme of commercial human rights post-Brexit. My name's Brendan McGurk. I'm an executive committee member of the HRLA. And before I start this evening, I want to just say three very quick things. First of all, an enormous thank you to Hogan Lovells. First of all, for their continuing support of the HRLA, and in particular for making this wonderful auditorium available for tonight's event. I want to say a particular thanks to Charles Brasted, who is a partner in public law here at Hogan's, and who is one of our speakers tonight. Thank you very much, Charles. Second, I wanted to say a few words about the HRLA. We put on 10 to 12 big set-piece events per year across the human rights spectrum, and there is, we think, something for everyone. We always attract high-quality speakers, and tonight is no exception. Many of you here are already members. For those of you who aren't, can I encourage you to think about joining? Membership is very, very good value indeed, and there's this further good reason for joining, in that the vast chunk of subscription money goes into our bursary scheme, and the bursaries help those who are budding human rights lawyers in the UK to do and undertake internships that they otherwise could not afford to undertake. All details of our events and the bursary scheme are available on our brand spanking new website at hrla.org.uk. Finally, after the three speakers tonight, we're hopefully going to have some questions from the audience, stimulate a little bit of debate, and after that, we would be delighted if you'd come and join us for some drinks upstairs, again, courtesy of Hogan's generosity. With that, can I hand over to our chair this evening, Tim Ward, QC.
Thank you very much, and welcome everybody. The phrase commercial human rights is one that is bound to bring a warm glow to the heart. And the question for this evening really is it going to be more important because of Brexit? Now, we have three people who are undoubted experts in this area. Charles, partner here at Hogan Lovells, one of the leading public lawyers in the city. He is a master of the black art of commercial human rights. Our other two speakers are also experts in the area, and while their expertise is not in doubt, their patriotism has been questioned, and that is because they were on the successful side in Miller. Now, Jerry's main claim to fame, no, sorry, that's unkind. One of Jerry's claims to fame is he persuaded a High Court judge to rule that some obscure provision swept EU law aside in its entirety. And that was obviously a precursor for Brexit. And funnily enough, the European Court didn't actually agree with our learned judge on that. Jessica is, of course, very well known to many people here as the editor of what is undoubtedly the best book on human rights law, the Big Blue Encyclopedia. Now, each is going to speak for about 15 minutes. Charles is going to go first and explain why he has a newfound passion for human rights in light of Brexit. Jessica is then going to be very gloomy for about 15 minutes about what are the rights we are losing. And then to make sure we finish on a really upbeat note, Jerry is going to talk about how we will use the rights that are left and enforce them effectively. So with that, I'll hand over to Charles.
Thanks, Tim. Having spent at least the last 2 years talking about Brexit daily, I learned one thing, which is that I should never make predictions. This evening, I intend to go one step further and provide absolutely no answers. At least in the next 10 minutes. I reserve my position when we get to the Q&A section. Instead, what I wanted to do was pose some questions about the future of commercial human rights after Brexit, on the assumption Brexit happens. I'm delighted to welcome you all here to Hogan Lovells this evening. The HRLA seems to be becoming something of a regular in this auditorium, which is a great thing. So for many of you, I suspect it is welcome back. It was about 3 years ago in this room that we hosted an HRLA event on, broadly, the rise of commercial human rights, as Tim would say, a subject to warm any heart. And it was at the time, I think, still a topic of some excitement. If a week is a long time in politics, and it certainly seems to be, then a few years is quite a long time in the world of commercial human rights. It is now, it seems to me, wholly conventional to regard human rights arguments as a staple of challenges to regulatory and governmental decisions that affect businesses. They are not, whatever the other side may say, merely a make-weight, but substantial grounds that can give rise to substantial remedies. They provide a legal basis for intense scrutiny of public decision-making, cast in terms of proportionality, but flexible in its intensity, and capable of taking the court, dare I say it, close to the heart of the merits of a decision. They also provide access to remedies that other public law grounds generally cannot reach, declarations of incompatibility of primary legislation, and importantly, for businesses, damages. There is now ample evidence of damages awards in human rights cases that are anything but nominal in their scale. So I take it as a given for this evening that human rights matter for businesses. The essence of my question, as Tim has already suggested, is will they matter more or less post-Brexit? For a depressingly large number of people, voters we call them, the assumption may be that they will matter not at all post-Brexit, because we are leaving Europe. So it's a pleasure this evening to be in a room full of people with just enough geography and maybe enough French to spot that Strasbourg is not Luxembourg. So our relationship with the European Convention on Human Rights and with the European Court of Human Rights will be, on its face, I suppose, unchanged by Brexit broadly. I will shy away, as promised, from speculating as to whether the long-threatened human rights reforms of the Conservative Party, whatever those may be, are closer or further away than ever before. I merely note that they have proven somewhat undeliverable to date and would raise yet more difficult questions regarding Northern Ireland and the devolution settlement across the UK at a time when we perhaps have enough such questions to be getting on with. What is, however, likely to change is that the European Charter of Fundamental Rights will no longer have any application in the UK. I say in the UK, it is slightly less clear to me at the moment that it will have no application to the UK, both in respect of any dispute resolution mechanism that apply to a future relationship, and of course the impact that it may have on the jurisprudence of the CJEU, which is intended to be preserved by the repeal bill. Does that loss of the Charter, if that is what follows, matter? Keith Vaz, the then minister at the time of the Charter being ratified, the Minister for Europe, said the Charter will be no more binding than the Beano or the sun. Of course, I realise now that most politicians do regard the sun, at least, as binding. The Charter was given legal force by the Lisbon Treaty in 2009, but both the UK and Polish governments secured a protocol saying that it did not create new rights in the UK or Poland that could be enforced by any courts. Protocol 30 is legally binding and applies to the obligations of both countries under the Charter. It's designed to clarify how the Charter applies and emphasises that it is not to be interpreted as imposing new obligations. It was, of course, isn't and was never intended to be an opt-out. Even so, there is an argument made by, among others, Marina Wheeler, QC, that this protocol is ineffective and that the CJEU has started to use the Charter independently in judgments that affect British interests. In practice, so far in the commercial context, I'm not sure that I have seen it deployed to any effect. What seems to me the more interesting question, perhaps, is what impact Brexit may have on the use and development of commercial human rights in the UK. The EU treaties and the general principles of EU law provide much fertile ground for challenges to UK public law decisions, regulation and legislation. They provide the foundation for proportionality assessment similar, if not identical, to that under the ECHR. They provide strong remedies in damages, and most particularly, of course, in the interpretation and disapplication of legislation. And they provide various specific safeguards against state action that inhibits, to put it in broad terms, competition and commercial freedom. In those senses, they matter to businesses, but they also provide something of a written constitutional legal framework for the control of governmental decision-making. Absent that legal framework directly applicable in the UK, the judicial review litigator's toolkit may look a little bare. But happily, both JR litigators and indeed judges are creative when it comes to holding government to account, and the common law is, of course, a living creature that belongs to the court and to we litigators. In the face of threats to the Human Rights Act, the judiciary was anxious to emphasise the non-statutory common law basis of fundamental rights. And there has also been some, although not decisive, movement in our domestic law towards a proportionality approach independent of EU or human rights law. I wonder whether the courts may now similarly seek to ensure that common law and human rights work hard to fill the gap that Brexit will create in our system of administrative law. However, it will be difficult for it to do so completely. Brexit was billed as a return of sovereignty. That sovereignty returns to Parliament. That sovereignty risks being taken as much from the realm of legal accountability as it is from the faceless Brussels bureaucrats. It is our job to ensure that domestic public law, which includes fundamental human rights, rises to the challenge, and challenges, I suspect, there will be plenty.
Charles, thank you very much indeed for that. Jessica.
So I'm going to cover three enormous issues. I'm afraid they're all tainted by the word loss. First, the likely loss of what I would describe as constitutional rights currently enjoyed by businesses based in Britain and the rest of the EU to provide goods and services across the territory of all member states. And central to this will be the loss by businesses of the right not to be discriminated against on the basis of nationality. Second, the loss of procedural rights for businesses, the potential inability of businesses to litigate, to enforce rights that will derive from an international treaty rather than from domestic law, and the potential loss of their right to enforce civil judgments across the EU. And thirdly, the potential loss of democratic rights after Brexit by virtue of the expansion of executive powers through the use of Henry VIII clauses and the risks that that involves for businesses. So turning to the first, the loss of constitutional rights. Traditionally, when we talk about commercial human rights, we tend to focus on the right to property. However, it seems to me that we need to widen that narrow approach. Over the past 60 years since the Treaty of Rome, businesses in the EU, including small businesses, entrepreneurs, and the self-employed, have been guaranteed 4 fundamental freedoms: freedom of movement of goods, workers and capital, and the right of establishment and freedom of services. And we might now, I would suggest, characterize those fundamental freedoms as rights in the same way as we do the right to, as we did begin to accept the right to non-discrimination or the right to vote. We cannot pretend those rights have existed forever. Indeed, if one thinks about it, the Treaty of Rome was only 8 years after the Universal Declaration of Human Rights and only 6 years after the Convention was opened for signature. The 4 fundamental freedoms have, moreover, been underpinned by perhaps the most important of all human rights, the right to non-discrimination and the right of access to court. So as I've said, the four freedoms underpinned by non-discrimination and access to court, I would say that they are the constitutional core of the single market. They allow individuals and businesses to operate across frontiers without restrictions, whether in relation to people, data, telecommunications, goods, services, and even taxes. Similarly, they allow customers or recipients of services to consume across frontiers without restriction, whether they do so themselves by moving or whether the goods and services move. Now, unless we stay in the EEA, those freedoms, or as I said, rights, will no longer be enjoyed by businesses operating in or from Britain after Brexit. It seems to me that there will be cases where the removal of certain of those rights will, however, be unlawful, as contrary to the human rights protections that we hope will be retained under the Human Rights Act. I give as an example mutual recognition of qualifications. If you're a Dutch architect who operates here, you're likely to be operating under the Mutual Recognition Directive. Now, the generous offer made by Her Majesty's government to EU citizens on Monday said that it hoped to preserve such rights, hoped, of course, being the operative word. Those rights are currently a negotiating card and therefore necessarily may not endure. Now, if that happens and the Dutch architect loses her established right to practice here, it would surely constitute a direct, and I would have thought unlawful, interference in her property rights. Now, even assuming that Parliament agreed to that removal of rights by way of primary legislation, there would remain the issue as to whether a remedy might be available in Strasbourg, or whether, for example, compensation would have to be payable. As regards discrimination, the same arguments might be made if the UK discriminates against any business that was here before Brexit, although I think perhaps more difficult in relation to an argument about discrimination after Brexit. Now, once the UK is a third country, it will, of course, be permissible for the other 27 states to discriminate against businesses or services that come from the EU, insofar, of course, as that doesn't breach any free trade agreement or WTO rules. And one could give as an example the Jersey low-value consignment relief case. In that case, the United Kingdom decided to remove low-value consignment relief in relation to low-value goods that were coming into the UK from the Channel Islands. The Channel Islands was treated as a third country in that context. And it was found that that was fine because whilst you could not discriminate between EU states, it was perfectly permissible for the United Kingdom to discriminate between China and the Channel Islands. So the right to non-discrimination in relation to third countries simply does not exist as a matter of EU law. Turning then to my second large issue, the loss of procedural rights, it seems to me there are two major risk areas for business. First, and potentially of grave importance, is the loss by companies of their ability to enforce trade rights through direct actions in the courts. If we end up in a relationship with the EU based on a free trade agreement, the dispute resolution mechanism is likely to be an interstate mechanism. And the consequence of that is that businesses that suffer from unlawful trade restrictions will have to petition the government to bring an action against the EU. And that, of course, takes one into the political realm, where the Commission will be thinking about its relationship with a particular state, and the government will be thinking about whether this is a particular issue they want to trade off against another one. Secondly, the enforcement of civil judgments. It is obviously crucial for businesses to be able to enforce its judgments in other states, and the Brussels regulations that have been developed over the years now provide a pretty sophisticated European-wide enforcement and recognition mechanism. And as I understand it from a piece in the Financial Times today, the Commission has produced a paper suggesting that UK judgments will not be recognised in the EU. And if that is correct, and it may of course just be a negotiating card, But if it is correct, it has massive implications for doing business here, not to mention for our legal system and indeed legal services industry. So my third head, the Henry VIII clauses. Now it's not clear how much of the Repeal Act and the White Paper will remain, bearing in mind the change in the political landscape since the election. But let's assume for the moment that the government continues as proposed before the election in relation to the Great Repeal Bill. Well, self-evidently, democracy and the rule of law is the lifeblood of human rights. And Henry VIII clauses are the anathema to those principles, since they give the executive untrammelled powers to amend legislation adopted by Parliament. I can't put it better than Lord Judge did in his 2016 lecture at King's before the referendum. He said, "The principle of parliamentary sovereignty is the foundation of our half-written constitution. Democracy and the rule of law are intertwined with it. The democratic process, as a process, has an outing every 4 or 5 years at the general election, and this is the important point, but it is only by the operation of parliamentary sovereignty that we remain a democracy on every other day of the year. Parliamentary sovereignty is the antithesis of executive sovereignty. The two concepts are mutually contradictory. The democratic process is not meant to give, and our constitutional arrangements were not intended to provide us with executive sovereignty, which is, of course, what Henry VIII clauses involve. I would add that because we have no written constitution, and after leaving the EU will lose the constitution that the EU provides us with, we are to a very large extent dependent on Parliament for the protection of human rights. And that is so, in my view, even taking into account the willingness of the courts post-Jackson to curtail parliamentary sovereignty by reference to human rights norms. It's certainly so, I would say, in the context of commercial human rights. There are, of course, real questions as to whether Parliament is up to the job, but that apart, the White Paper indicates that in any event, there is a real risk that Parliament will give these Henry VIII clauses to the executive. Now, the White Paper says that Henry VIII clauses are intended to deal with areas where the direct conversion of EU law will not work. It states that this applies in relation, in its words, to a very significant proportion of EU law. The purposes for which it's proposed to use Henry VIII clauses are set out in 3.3, and I'll quickly read them to you or summarise them. First of all, to deal with gaps where some areas of converted law will be entirely unable to operate because we're no longer a member of the EU. Secondly, to deal with cases where EU law will cease to operate as intended or will be redundant once we leave. Thirdly, to deal with cases where EU law is based on reciprocal arrangements with all member states treating certain situations in the same way. And then it says the extent to which that will be necessary is uncertain. To deal with similar issues, as the fourth one, to deal with similar issues in legislation made by devolved ministers or enacted by devolved legislatures. Further, the paper calls for the use of delegated powers in order to legislate so as to take account of the outcome of negotiations and to reflect the contents of the withdrawal agreement. The justification given for doing this by way of Henry VIII or secondary legislation rather than through Parliament is first, the government says, matters which cannot be known or may be liable to change at the point when primary legislation is being passed because the government needs to allow for progress in negotiations. So pretty vague. Secondly, adjustments to policy that are directly consequential on our exiting the EU. And thirdly, to provide a level of detail not thought appropriate for primary legislation. Again, very vague. Now, when one looks together at the challenges addressed and the reasons given for using Henry VIII powers to address them, I would suggest that the potential growth in executive power is vast and indeed, on its own admission, actually unknown. Moreover, the justification for the powers is very close to that was given by Henry VIII himself in the 1539 Statute of Proclamations. He said that he had been frustrated by willful, obstinate, and froward people, which I looked up, by the way, and it means difficult and perverse, in his attempts to act in the interest of the people, and that, to quote, sudden causes and occasions fortune many times, which do require speedy remedies, and that by abiding for a parliament in the meantime might happen great prejudice to ensue to the realm. So for that reason, his acts of proclamation should be obeyed. Just to end on a note of optimism, and again, as pointed out by Lord Judge, a careful reading of the Statute of Proclamations shows that Parliament in fact refused to give Henry VIII the powers he sought. And indeed, that statute provides a clause to preserve all existing rights. All that the Statute of Proclamations in fact gave Henry VIII was the power to enforce acts that he was entitled to do by way of the prerogative through a special council. And by the way, the act failed and was repealed 8 years later.
Jessica, thank you. I'm sorry if our arrangements are not up to the standards of the 16th century. Jerry is going to now be relentlessly upbeat about all the great things we'll be able to do even after Brexit happens.
I'm not so sure about that. Anyway, it does fall to me to be slightly upbeat at the end of it. I did some slides as well. I don't think they've been printed out, but if anyone thinks they're useful enough to have a copy, you can get a copy from HRLA or from me afterwards. So first of all, what is the status of EU law going to be after Brexit? Again, as Jessica said, there must be some doubt over whether the Great Repeal Bill in the form proposed in the White Paper is going to end up in that form. But in any event, the proposals at least are that it will convert directly applicable EU law, that's essentially EU regulations, into UK law, that it will preserve UK law which already implements directives, that it will maintain directly effective treaty rights, although not the EU Charter, that there will still be a requirement to interpret all of that EU-derived law in accordance with the EU treaties, that there can be a continued reliance on pre-Brexit CJEU case law for interpretation of that EU-derived law, and that indeed EU law will still continue to take precedence over pre-Brexit domestic law, but not any primary legislation which is passed after the date of Brexit. So in one sense, and indeed this is what the notes to the Queen's Speech and the White Paper about this bill say, they are intending that there will be, the law in a sense will be the same on the day after Brexit as it will be before, insofar as possible. So as Jessica said, there are lots of areas of EU law, common regulatory frameworks and so on, which simply can't work when you're not a member state, and they will have to address those in some way. But at least insofar as we're talking about EU law, which does work even when you're not within the EU, that ought to be the same on the day after Brexit as it is the day before. So in terms of pre-existing disputes, the reality is that whether you're talking about commercial disputes or any other kind of disputes, right up until the day that we leave the EU, and indeed probably for a significant period of time afterwards, indeed in some cases maybe many years afterwards until Parliament gets around to amending a particular area of the law, pre-existing disputes will still be determined according to EU law, according to the ECJ's pre-Brexit interpretation of EU law, according to the underlying purpose of the relevant EU legislation, if it, depending on the legal base in the treaty. So there are lots of ways in which you will be able to continue to rely on EU law. Many of you will recall the famous line from Lord Denning's judgment in Henson Berry that it was bluebell time in Kent, and of course, whatever the legal situation is on the date that the dispute arises, that will have to be it will have to be determined according to what the law was on that date. So again, you could have a dispute which arises on the very last day before we leave the EU. It works its way all the way up through our domestic courts, and not quite clear yet whether there's going to be a possibility of making references after we leave. But even if you don't get a reference to the ECJ, the domestic courts will have to determine that according to EU law. Post-Brexit, new case law from the ECJ. But the reason I put this case law in is because you'll see that the ECJ's view is that when it gives a judgment interpreting EU law, that tells you what EU law is and has always been from the beginning. Now, on the approach that seems to be adopted under the Great Repeal Bill, if the ECJ clarifies some aspect of EU law after we leave, the courts will not be obliged to take that into account. But I mean, I would have thought, just going back to the sort of arrangements, if you go back to the days of ex parte Brind, for example, that our courts will have regard, at least out of judicial comity, to what that international court has said EU law was intended to mean from the beginning. But there remains some uncertainty about that. The Bar Council's paper has actually published quite an interesting paper on the role of the CJEU after Brexit, which covers some of these issues. I've got one slide on potential losses. Jessica's talked about some of them. I agree with everything she said. There are clearly some things which are important in commercial and other litigation which are going to be lost. So the EU remedies that we've become used to, disapplication of inconsistent law, making a reference to the ECJ, consistent interpretation, Frankovich damages, they're all going to go. Oversight by EU institutions. You shouldn't downplay this in a commercial context, whether it's complaining about a competitor who's been given state aid, whether you're complaining to the Commission about a member state introducing some new technical standard without going through the appropriate process. Tim and I did a case about the e-commerce regulation, which restricts the extent to which member states can regulate e-commerce services coming from another member state. Those are all things which currently are subject to oversight by the Commission to a greater or lesser extent, and obviously we're going to lose that. Jessica's talked about the internal market rights, which are not strictly speaking human rights, but are commercial rights, established commercial rights that we have. There's a nice example, which was in some of the paperwork in Miller. If you are a UK company who currently buys widgets from a dominant German company, it would be an abuse of a dominant position for that German company to sell you those widgets at 10% greater than the price that it's selling into the Belgian market, unless there's some objective justification. As soon as we are no longer a member state and subject to whatever is in the agreement, you as a British company will no longer be able to complain about that discriminatory pricing. By definition, that will not be an abuse of a dominant position that affects the internal market because we won't be in the internal market. So there are some substantive commercial rights which undoubtedly will not only be lost, but which are simply incapable of replication when you're not a member state. Some charter rights, query to what extent they really matter, some of them at least. And then, again, I think this is the point that Jessica was really majoring on in her second topic. The ability that you have as an economic operator within the EU to rely on EU fundamental freedoms to really establish your rights and indeed override other fundamental rights. There's the Viking and the Laval cases where free movement rights, the fundamental freedoms, were found essentially to trump the rights of collective action of trade unions in certain circumstances. And obviously, once the internal market rights are gone, you won't be able to rely on those anymore. But when it comes down to it, and when you talk about commercial rights, it always seems to me that really there are two core rights that you're talking about. One is the right to property in all its various forms, and the other is the right to privacy, confidentiality that companies have. And then there are procedural rights which generally go towards protecting those underlying substantive rights to property and confidentiality. There are, I've put them in square brackets, some rights around the edges. Companies do have the right to freedom of expression, not to be discriminated against. Religious organisations obviously have the right to exercise their religious beliefs and so on under both the Convention and the Charter. But I'm really going to concentrate on property and privacy. And in my view, when you analyse it, in fact, you may find that the protections which are already and have always been there in domestic law, coupled with the protection that we still have under the Convention, at least for the moment, mean that, in truth, companies may not be losing very much in relation to these core substantive rights. So turning first to the right to peaceful enjoyment of property, that is self-evidently a right which has enjoyed clear fundamental protection in the common law going back for several hundred years. You can go back to Ettrick and Carrington as the famous case, but you see it recently referred to in more recent UK Supreme Court case law, in particular Ahmed, the reference there referring to Liversidge and Anderson. Moreover, as in any developed legal system, our legal system has extensive protections for property rights, both under the civil and criminal law, the law of property, criminal damage, theft, intellectual property laws, tort, the protections which are built into the compulsory purchase process. So all of those rights are already there in one form or another across our legal system. And then when you come to international law, most obviously the Convention, Article 1 of the First Protocol, on its face applies to legal persons, there's no doubt about that. You only have to look at the UCOS judgment and literally thousands of other Strasbourg judgments over the last few decades to see the way in which it can apply to business property, commercial property. But bear in mind, it's a highly qualified right. I mean, the right under Article 1 of Protocol 1 is subject to extensive controls on the right to use property and enjoy your property in the general interest, subject to a proportionality test and a legitimate aim and so on. But to the extent that our domestic law does not provide at least equivalent protection for the right to property, I think, again, you would expect our courts going back to a sort of pre-HRA arrangement where they will say that domestic law, including the common law, ought to be interpreted to ensure at least the same level of protection that you find in customary international law, including the Convention. Privacy rights, again, these are pretty limited so far as companies are concerned. Obviously, companies have the right to confidentiality of their correspondence, of their communication, to protection of their intellectual property and their commercial property. But again, those are all substantive rights which you find in one form or another in domestic law as it is, whether you're talking about equitable breach of confidence, defamation, misuse of information, and so on. Data protection is quite an interesting one. Companies can, particularly individuals, self-employed individuals, obviously can have data protection rights. Companies obviously are protected by the protections given in the investigatory powers legislation about protecting you from interception and confidentiality of your correspondence. Data protection appears at the moment that the UK's position is that we will obviously have to implement the General Data Protection Regulation before we leave the EU in any event, and the position seems to be that we will continue to comply effectively with EU data protection laws because we frankly won't have a choice, in the same way that the US has had to come to an agreement to ensure so-called adequate protection in order that personal data can be transferred back and forward between the EU and the USA. The UK, as a third country, will effectively be obliged to sign up to and to have at least the same level of protection for data protection for personal data as the EU has. And that is an area where many of you will know the ECJ has been incredibly proactive at pushing the law forward. And it is an example where it has relied expressly on the EU Charter to develop the law in a way that goes beyond Strasbourg case law. So you see that in the Davis and Watson case, you see it in Schrems, in Google Spain, the right to be forgotten. These are all judicial constructs of the European Court of Justice, and it's really taken privacy as somewhere where it's really leading the charge, and Strasbourg is following. So we will find that even if we have escaped the jurisdiction of the ECJ, it's very unlikely that we'll be able to escape its jurisprudence. Finally, procedural rights. As I said, these are largely relate to protecting, in a commercial context, the underlying rights we've just been talking about. But as Charles said, you can already see and have seen over the last 5 or 6 years a movement, particularly in the Supreme Court, towards emphasising the protections which are already there in the common law for some of these procedural rights, for the right to be heard before your rights are interfered with. You see that in Bank Milat, even though that was a case which was expressly argued on an Article 1, Protocol 1 basis, it was effectively decided by reference to common law principles of fairness. The principle of legality, i.e. that rights can't be taken away except through express statutory words, affirmed most obviously recently in Miller. General public law principles of reasonableness, fairness. There is a general public law principle in English public law of consistency, which does give you a right not to be discriminated against. It gives you the right to have similar cases treated in the same way and different cases treated differently. Rights of substantive legitimate expectation. And again, as Charles said, although we're not quite there yet, there are at least signs that in some contexts, particularly in a fundamental rights context, the courts have been willing to say that effectively the common law provides the same level of protection as the standard of proportionality. And I'm sure that although much of this jurisprudence came about in a context where what they were really concerned about was losing the HRA and potentially even leaving the convention, I'm sure that you will see, particularly on the part of the senior judiciary, an anxiety to ensure that as we leave the EU, the common law comes to the fore again, that we perhaps shift our focus to some of our own historical, long-standing protections for some of these fundamental rights.
Fantastic. Thank you very much, Jerry, and thank you again to Charles and Jessica. Just one comment from me, really echoing what Jerry was saying. Thinking about the way the Great Repeal Bill or Act is going to work, it's very hard to imagine being in court and the judge having to grapple with the fact that if events had happened at a certain time, these embedded general principle type protections in EU law would apply. But if they happened a week later, then actually none of those principles would bite. And where there's enough flexibility in the common law to give effect to it, I'd have thought there'd be quite a strong appetite, at least among some judges. That's very different from some technical rules about sheep meat premium or something. But the kind of general principles we've been discussing this evening, I think one can be cautiously optimistic about. Anyway, on that cheery note, any questions or comments, please? Yeah.
I'm just wondering, what role, if any, do you see international investment law playing in this space? Because I think I don't know to what degree the UK has any VITs with any EU nations, given sort of when we entered the EC. But some of the standards that you were talking about, as sort of non-discrimination, due process, that sort of thing, all that is standards that apply regularly in international investment law and could be used either against the UK or if we are to take steps to increase or to create VITs with EU nations going forward that could protect UK businesses. I'm just wondering where you see international law playing a role in this entire space, if any.
Having a go?
I don't know whether I have to press this button, maybe I don't. It's on, okay. Well, there are two sides to this, I suppose. First of all, there is, I understand, a lot of litigation that is in its early days potentially against the UK in relation to Brexit itself being in breach of bilateral investment treaties. And then there is I didn't mention this in the context of potential sort of rights for companies, but obviously, apart from the free trade agreement, there is likely to be some kind of investment treaty agreement, which I suppose may be between the UK and the EU or bilateral. And I believe that the Commission is trying to set up, and has been for several years now, a multilateral investment tribunal. And in that context, of course, investors will have direct rights of action, so they won't have to go through their states. But I think it's obviously going to be a very important and relevant part of the dispute mechanism, and in a sense separate from day-to-day trade disputes.
Charles?
I think just to add to that, every draft of the deal that we're going to do that I've seen in the sort of pro-business bits of government and private sector that we've been talking to assumes the inclusion of an investor-state dispute settlement mechanism in the overall deal. Now, of course, and there are obviously good reasons for that. Does it fall short of what we have at the moment? Of course it does. And the other important thing to note about it, I think, is that it is that mechanism, or things like it, that proved the most controversial and difficult bit of things like the EU-Canada free trade agreement, and that held that up for so long. So as you say, the EU is keen to develop more of a multilateral, in effect, international court, which is even more controversial. So there is a mechanism there. it's certainly one that's being vigorously pursued by business and business bits of government. But how quickly that can be delivered is somewhat unclear to me.
Anybody else? Yes, Peter?
Thank you. My name is Peter Oliver. I'm Moncton. I'm actually writing a book about the fundamental rights of companies, which I've been writing for a very long time, but not in relation to Brexit. In fact, I started writing it long before the referendum, and it's to be published next year by Hart Publishing. But if I could just react to the last question, if I may, and follow on from what you say, the CETA, the agreement between the EU and Canada, is the controversial part is precisely this very aspect. And Belgium is about to lodge a request to the European Court of Justice for an opinion as to whether this mechanism is compatible with the EU treaties. And the objection is precisely that it sidelines the normal access to the courts. So, and there's a very, very strong feeling about it, not just in Belgium, but in quite a lot of member states, not only amongst politicians, but also it's a general public demonstration of Germans. And it's quite possible that the Court of Justice will actually say that it is contrary to the treaties. So that is obviously something to watch for the Brexit negotiations. And I don't know whether the opinion will come out before Brexit, because these opinions are under Article 218 take a very long time. It's all the judges sit. So you have 27 judges sitting on it, and it takes about a year and a half. Thank you.
Was there another?
Yeah, my question is really on the enforcement of those rights for British corporates in the EU, in that most of your discussion really has been based on how those rights would be enforced here, but the big issue faced by most British corporates, be they large scale or small scale, is how to protect those rights of non-discrimination in the vast sales of goods and services they have across the currently other 27 countries. How will they be able to protect those rights in two parts? The large corporates often have operating subsidiaries in Ireland and the Netherlands and Luxembourg at the very least, legal structures. But for the small corporates in fintech, finance, they often derive a huge proportion of their revenues from sales of services to EU countries. And how will they be able to protect themselves from governments which tend to favour local contractors, especially in countries like Italy, Germany, Spain, that are notorious within that sphere?
Very good question. Who would like to go?
I mean, I think that's very clearly, if you're looking at the commercial rights which are at risk, that's the clearest of them all. And whether that can be replicated and the extent to which it can be replicated for a UK company which does not have an EU establishment sufficient to enable it to rely directly on EU rights is a matter which will be totally determined by the terms of the agreement. So,
I think that's right. I mean, of course, if you have got a subsidiary within the EU, then you will, in relation to that business, and so far as you're established there, you will benefit from all EU rights. So the system will be exactly the same, except that you'll go through the Irish or French courts. But if you're just as a third country providing services so it's going to depend on the agreement, as Jerry said.
Thank you. Sorry, Charles.
Sorry, I was going to break my own injunction against predictions. My one prediction is that the scope of freedom of capital, which of course is one of the only fundamental freedom that applies as against or as regards third countries as well as member states, will be further tested in the coming years.
Yes, that is true.
Someone at the back, yes.
Jessica mentioned about maybe Article 1, Protocol 1 having been used in disputes between companies and trade unions and assisted commercial parties in those disputes. And the question just asked concerned at least related to the ability services, and previously the freedom of capital would have meant that you couldn't discriminate between the two. You couldn't discriminate over preference for local services, say. And one of the criticisms of the Health and Social Care Act was that the size of clinical permission groups meant that they were procuring on a level that they too couldn't prefer local services, but rather to go to that which was simply the better in terms of sheer competition. So stacked up together, in that Jerry mentions that this is the area where it will make the biggest difference. Might Brexit actually be something positive for those who would like to see something more of a leftward shift in politics?
Yeah, well, I mean, if you have an interest in being able to discriminate in favour of UK companies as against EU companies, then undoubtedly, again, subject to the terms of the agreement, we'll be able to do that. But it depends on your point of view, whether you think that rules which require procurement across a large internal market or without discrimination on grounds of nationality are a good thing, or whether you have a preference that those who procure goods and services are able to express a local preference.
Although I suspect if we wish to do a free trade deal with any country in the world, then that sort of shift would be inconsistent with that. So it's wholly unrealistic.
Yeah. And as I understand it, free trade agreements are moving more and more towards covering procurement as part of the deal.
Good. Yes.
Thanks. A question for Charles, if I may. I'm actually on right, Downton Street Chambers. The run-up to before the question is this. At 5:45 this morning, the chair of the Bar Council... 5:45 this morning, the chair of the Bar Council on Farming Today said that no deal would be ruinous for UK farmers. So the question for you is, do you think UK farmers could be the poster boys for commercial human rights?
I'm not sure that British farmers have ever been that attractive a poster boy band, as it were. Are they the most deserving of candidates for that role? I don't know. There may be others on this panel who think they're alternative candidates. But it is, of course, I suppose the question will be what is the target against which they will be deploying their human rights. And is that a target that's amenable to them? And I suspect that some people on this table will be kept occupied for many years looking for those targets very vigorously.
I mean, there's a question as to whether acquired rights, so rights which you currently enjoy, can be property rights, for instance. So, I mean, one of the, I gather in this stuff that came out from the Commission today, one of the things that they talked about was companies who have already placed goods onto the market in the United Kingdom. They would hope that the mutual recognition which has allowed those goods to be placed on the market would continue. So there would be rights which have already been acquired. Another set of acquired rights is if you've entered into a contract already which requires you to be delivering or receiving goods as between the EU and the UK. And there is a question as to whether those are acquired rights which will be taken away if there's no deal, or if you do a deal which doesn't take account of those rights. I mean, do people have a right to expect compensation in relation to that?
And there are even more complicated acquired rights, I suppose, which are those that are contingent.
Yes.
So rights, for example, as a commercial agent, which are accruing and have accrued, but may not come into play until some future date, as yet unknown, which may never occur. I don't know the answers.
So my question's in regards to a couple of you mentioned about filling in the gaps and the common law taking the place of the European judiciary. And my question is,
do you think, given past case law and the reluctance of the judiciary to fill in the gaps and leaving it more to the parliamentary sovereignty space, do you think that they will actually rise to that challenge, or do you think that they will take a step back and say, no, this is for the Parliament to create legislation?
Well, I would say where there are gaps, we're going to be fine. The problem is going to be where Parliament does fill in the gaps. And when Parliament does fill in the gaps and fills them in clearly, the big question is whether Parliament, even though, whether the courts, even though Parliament has filled in the gaps, are willing to step in. I think where you're talking about spaces, I believe the judiciary now will apply proportionality, legitimate expectation, all the concepts that derived from EU law that have now become the sort of staple of English public law.
Thank you. Yes.
Jerry and Charles both mentioned that in terms of core fundamental rights, not much will change because of the convention. Of course, withdrawing from the convention wasn't in the Conservative Party manifesto prior to the general election. With reference to counter-terrorism, Theresa May said that if human rights laws got in the way, the government would think about what to do with them. Some people saw that as a veiled reference to the possibility of derogating from the convention in times of emergency. Apologies for asking you to make another prediction, but what are your thoughts on that, how that could play out?
Anybody?
I mean, speaking for myself, I think the chances of us leaving the convention are now very low, at least in the next 5 years. I think it was a pet project of Theresa May in particular, and of some parts of the... I mean, it didn't have support across the whole Conservative Party. There's quite significant numbers in the Conservative Party who are aghast at the idea that we might leave the convention. So I think, I mean, it's not going to happen in this Parliament. Obviously, things would have to change quite significantly. And I think once we are, if we are out of the EU, once we're out of the EU, there will be a realisation, I think, that our membership of the Convention is perhaps even more important than we thought it was. So, I mean, I'm hopeful that that's something which is not going to happen anytime soon.
I agree with that. I also think if we leave, and I still believe it's an if we leave the EU, we are going to feel very outside, very much an island. So when we turn up at, we're not going to be there at the grand summits in Florence and Paris and Berlin. We won't be on the photographs. And we'll turn up at the G8, G7, G20, and we won't have been there as part of the EU conversation. So I think we'll be clinging on to any international groupings that we belong to. So I also think it's very unlikely we'd leave the Council of Europe now.
Or we can join Belarus. They're not either, are we? Yeah. Any more questions or comments? No? Well, just let's say thank you both to the HRLA, to Hogan Lovells, and our three fantastic speakers.
And I just want to say very much thank you to our panel and to our hosts, Hogan Lovells. And from the conversation this evening, we're either going to have the roles building, pushing forward the development of common law human rights in a way that we have never seen before, or we are going to have British farmers sending in tractors on Strasbourg to enforce their required rights. I'm not quite sure what might offend the Daily Mail more. But either way, the Human Rights Lawyers Association will continue trying to drive the conversation forward, and I hope that you will all continue to play an active part. If we can thank our excellent panel in the usual way, and then go and have